Chapter 1. The City of Promise. On March 12, 1987, Robert Kensington received a letter that would destroy his life. It arrived in a plain white envelope, no return address, postmarked from a county office he'd never heard of. Inside was a single page with a government seal at the top and 3 sentences that made no sense. RE. Property Dispute Notification. Your residence at 447 Ocean Vista Drive is located on land currently under active legal claim by multiple parties. Please contact this office within 30 days to verify ownership documentation. Robert read it 3 times standing in his driveway, his coffee going cold in his other hand. Then he called his wife. "Carol, did we buy our house legally?" She laughed. Of course they had. They'd signed papers, hired a lawyer, paid a mortgage for 6 years. Their kids' height marks were penciled on the kitchen doorframe. Their dog was buried in the backyard. This was their home. But that letter wasn't a mistake. Robert Kensington lived in Cape Meridian, Florida, a coastal development town that didn't exist on any map before 1981. It was built from nothing. 2,400 acres of empty coastline transformed into a grid of streets, houses, parks, and the promise of the perfect American retirement. The developer, Meridian Shores Corporation, had sold it hard. Full-page ads in newspapers across the Midwest, free weekend tours with catered lunches, a sales pitch that sounded like scripture. Own your piece of paradise before it's gone. And people believed it. Between 1981 and 1986, over 1,200 families bought property in Cape Meridian. Most of them paid in full, life savings, cashed-out pensions, sold family homes up north. Some buyers never even visited before signing. They trusted the glossy brochures. They trusted the contracts. They trusted the notarized deeds with the county stamp that looked official enough to hang on a wall. What none of them knew, what the sales agents never mentioned during those catered tours, was that Meridian Shores Corporation didn't actually own the land they were selling. Not all of it anyway. In 1979, 2 years before the first house was built, the land had been sold twice. Once to Meridian Shores Corporation by a man named Douglas Fentriss, a local real estate speculator who claimed to have clear title going back to a 1923 land grant. And once, 6 months earlier, to a holding company called Argent Gulf Properties, in a private sale that was recorded in a different county, filed under a different name, with a different surveyor's map that showed the exact same coordinates. 2 sales, 2 owners, 1 piece of land. For 7 years, nobody noticed. Meridian Shores built houses. Families moved in. A post office opened. A small church held services in a rented hall. Cape Meridian became real, not legally, but practically. It had mailboxes. It had property taxes. It had people who called it home. And then in January 1987, someone at Argent Gulf Properties opened an old file and realized they owned a town they'd never visited. The first lawsuit was filed on February 4, 1987. Argent Gulf Properties versus Meridian Shores Corporation. The claim was simple. Meridian Shores had sold 1,200 properties on land they didn't own. Every deed was invalid. Every sale was void. Every family living in Cape Meridian was, legally speaking, trespassing. The letters started arriving in March, not just to Robert Kensington, but to everyone. Retirees who'd moved from Michigan, young families who'd bought starter homes, a widow who'd spent her late husband's insurance payout on a cottage near the beach. All of them opened their mail and found the same 3 sentences. At first, people assumed it was a scam. Then they called their lawyers, and their lawyers said the same thing. We need to see your deed. So they pulled out the documents, the thick packets they'd signed at closing. The deeds with the embossed seals, the surveys with the property lines, the title insurance policies that were supposed to protect them from exactly this kind of problem. But when the lawyers looked closer, they found something none of the homeowners had noticed. The deeds referenced a survey filed in Monroe County in 1980. clean, official, notarized. But Argent Gulf's deed referenced a survey filed in Collier County in 1979. Different map, same land, earlier date. Which meant that legally, Argent Gulf had gotten there first. By April, Cape Meridian wasn't just a town. It was a case study, a legal anomaly, a place where over 1,000 families had bought homes that, according to the state of Florida, didn't belong to them. The local news picked it up first, then the regional papers. By May, it was national. Ghost town, how an entire Florida community was sold twice. Lawyers descended on Cape Meridian like a plague. Some represented the homeowners, filing class action suits against Meridian Shores Corporation for fraud. Others represented Argent Gulf, demanding the land be cleared so they could exercise their legal property rights. A few represented the banks, which had issued mortgages on houses that might not legally exist. And in the middle of it all was Douglas Fentriss, the man who had sold the land to Meridian Shores in the first place. When reporters tracked him down in June 1987, he was living in a beachfront condo in the Bahamas. He agreed to an interview, but only over the phone. His lawyer was present. His answers were careful. Did you know the land had already been sold when you sold it to Meridian Shores? I sold land I believed I had clear title to. But you didn't verify the title before the sale. That's what title companies are for. Mr. Fentriss, were you aware that the same parcel had been recorded under 2 different county systems? Long pause. I'm not going to speculate about record-keeping errors that occurred at the county level. The interview ended shortly after, but the question remained. How does someone sell the same piece of land twice? The answer, it turned out, was easier than anyone wanted to admit. In Florida in the late 1970s, land records were a mess. Different counties used different filing systems. Surveys weren't digitized. A single piece of property could be described 3 different ways depending on who filed the paperwork and when. If you knew how the system worked, or more importantly, how it didn't work, you could manipulate it. And Douglas Fentriss knew. He'd sold the land to Argent Gulf in 1979 using a survey filed in Collier County. Then, 6 months later, he'd refiled a nearly identical survey in Monroe County under a slightly different property description, same coordinates, different language, and sold it again to Meridian Shores. Both sales looked legitimate. Both were notarized. Both were recorded. And because the counties didn't cross-reference their records, nobody caught it. Until 1987, when the whole system collapsed. By summer, Cape Meridian was in legal limbo. Homeowners couldn't sell. Banks froze mortgages. Insurance companies refused to pay claims. The town had mail delivery and a zip code, but according to the state, it didn't legally exist. Robert Kensington stopped sleeping. He'd spend nights at his kitchen table, staring at the deed he'd paid $127,000 for, running his finger over the embossed seal, like it might suddenly become real if he touched it enough times. During the day, he'd call the county office and get transferred between departments until someone finally told him, "Sir, we're aware of the issue. There's nothing we can do until the courts decide." "But I own my house," he'd say, his voice cracking on the word own. "That's for the judge to determine." The worst part wasn't the uncertainty, it was the realization. The slow, sick understanding that every assumption he'd built his life on, that contracts meant something, that signatures mattered, that the government wouldn't let you buy something that didn't exist, was wrong. He'd worked 30 years as an electrician in Ohio, saved every extra dollar, bought this house for his family's future, and now a lawyer in the Bahamas and a filing clerk's mistake had turned all of it into a legal fiction. His wife found him crying at the table one night in July. Not loud, just silent tears running down his face while he held their deed in both hands, like a prayer that had gone unanswered. In August 1987, the case went to trial. It lasted 3 weeks. By the end, The judge made a ruling that satisfied no one and devastated everyone. Argent Gulf Properties held the superior claim. Their deed was earlier. Their title was valid. They owned the land. But the homeowners weren't evicted. Not immediately. Instead, the judge froze everything. No one could sell. No one could leave. The town was locked in place, while the courts figured out what to do with 1,200 families who had bought homes that didn't belong to them. Cape Meridian became a ghost town that people still lived in, and Douglas Fentriss was never charged with a crime. Because technically, he hadn't broken any law. He'd exploited a loophole in a broken system. He'd sold land he didn't own to people who believed they were buying their future, and when it all collapsed, he walked away clean. The real question, the one that would haunt Robert Kensington and every other family in Cape Meridian for the next decade, wasn't how Fentriss had done it. It was simpler than that. If you can buy a house, sign a deed, pay a mortgage, live in it for 6 years, and then be told it was never yours, what does ownership actually mean? And if the answer is, whatever's written on the right piece of paper, filed in the right office, on the right date, then who really owns anything at all? Chapter 2. The Man Who Sold Paradise Twice. Douglas Fentriss wasn't supposed to be a criminal. He was supposed to be exactly what his business card said. Land development consultant. A middleman. Someone who connected buyers with sellers, matched investors with opportunities, and took a percentage for making introductions. In the world of Florida real estate in the 1970s, that was a respectable profession, even a lucrative one. But Douglas Fentriss had a problem. He was good at spending money and terrible at keeping it. By 1978, at age 42, he'd been married 3 times, divorced twice, and was working on his 3rd. He drove a Cadillac he couldn't afford. He wore expensive suits that were always slightly wrinkled. He belonged to a country club where his membership fees were 6 months overdue. He looked successful, which in Florida real estate was almost as good as being successful. Almost. The truth was uglier. By late 1978, Fentriss owed money to 3 different banks, 2 private lenders, and his ex-wife's attorney. His consulting business was barely breaking even. He needed a big deal, something that would clear his debts and set him up for the next 5 years. And then in November 1978, he found it. The land that would become Cape Meridian was 2,400 acres of coastal scrubland, about 40 miles south of Fort Myers. It wasn't beautiful. It was swamp, palmetto, and sand. But it had 2 things that mattered in Florida real estate. It touched the Gulf of Mexico, and nobody was paying attention to it. The property had changed hands 4 times since 1923, passed down through families, sold to settle estates, traded between speculators who never visited it. By 1978, it was owned by an elderly widow in Jacksonville named Ethel Morehouse, who had inherited it from her father and had no idea what to do with it. She paid property taxes every year on land she'd never seen. When Fentriss called her in November 1978 and offered $180,000 cash for the entire parcel, she almost wept with relief. "Are you sure it's worth that much?" she asked. "Ma'am, with the right development, this land could be worth millions." He wasn't lying. Not exactly. The sale closed in December 1978. Fentriss paid with money he'd borrowed from a private lender at 18% interest, secured against the land itself. The deed was filed in Collier County using a survey that had been drawn in 1954 and hadn't been updated since. Fentriss now owned 2,400 acres of Florida coastline, and he had 6 months before the loan payments would bury him. He started shopping the land immediately. He contacted developers, investment groups, anyone with capital who might be interested in turning swampland into a resort or a residential community. Most passed. The land was too raw. The infrastructure costs were too high. The market was soft. But in March 1979, he got a call from a company called Argent Gulf Properties. They were based in Delaware, which should have been the first red flag. They had no office. No phone number except an answering service. No one Fentriss spoke with ever gave a full name. But they had money, and they were interested. The negotiations took 2 weeks. Argent Gulf offered $340,000 for the entire parcel. Fentriss would double his money, clear his debts, and walk away clean. The only unusual condition was that Argent Gulf insisted on using their own title company and their own surveyor. Fentriss didn't care. A sale was a sale. The closing happened on April 18, 1979, at a law office in Miami. Fentriss never met anyone from Argent Gulf in person. Their representative was a lawyer who showed up with a cashier's check, signed the papers, and left. The deed was filed in Collier County using a new survey, same land, GPS coordinates instead of the old meets and bounds description. Fentriss walked out of that office with a check for $340,000, minus the loan payoff, minus closing costs. He cleared about $140,000. It was the biggest payday of his life. He celebrated at an expensive restaurant in Miami Beach, ordered champagne, tipped the waiter $100, called his girlfriend and told her to pack for the Bahamas. And then, 3 days later, sitting in a hotel room in Nassau with his second bottle of champagne and a view of the ocean he'd just paid for, he had a thought. A terrible, brilliant, absolutely insane thought. What if he sold it again? His heart kicked in his chest, not from fear, but from something worse. Excitement. The same rush he'd felt the first time he'd closed a deal that shouldn't have worked but did. His hands started shaking. Not from the alcohol. From the realization that he'd just stumbled onto something that could either make him rich or destroy him, and he wasn't sure which possibility scared him more. The logic was simple. Argent Gulf had filed their deed in Collier County using the new GPS survey. But the original deed, the one from Ethel Morehouse, the one filed in Monroe County using the old 1954 survey, was still on record. 2 counties, 2 surveys, same land. If Fentriss refiled a deed in Monroe County using the old description, it would look like a completely separate parcel. And because Florida counties didn't cross-reference their records in 1979, no one would catch it. It was fraud. Obvious, blatant, criminal fraud. But it was also, technically, possible. He spent 2 weeks in county offices that May, moving between Monroe and Collier like a man casing a bank. He studied the surveys, compared the legal descriptions, checked the filing systems, and he found the gap he needed. The old meets and bounds language looked nothing like the modern GPS coordinates. Same property. Different paperwork, invisible to anyone who wasn't specifically looking for it. On June 3, 1979, Fentriss filed a new deed in Monroe County, claiming he still owned the land he'd purchased from Ethel Morehouse in December 1978. He made no mention of the April sale to Argent Gulf. Why would he? That was filed in a different county, under a different description. On paper, Douglas Fentriss now owned land he'd already sold. And in August 1979, he sold it again. The buyer was Meridian Shores Corporation, a development company out of Tampa, looking for coastal land to build a retirement community. They paid $520,000. The title company did their search, in Monroe County only, and found no problems. The sale was clean, legal, notarized. Meridian Shores broke ground in 1981. By 1986, they'd built 1,200 homes and sold every single one. And Douglas Fentriss, sitting in his condo in the Bahamas, watched it happen from a distance and convinced himself he'd gotten away with it. Until January 1987, when someone at Argent Gulf finally checked their records and realized they owned a town. When the lawsuit was filed, Fentriss hired the best lawyer money could buy. Not to defend him, there was no defense, but to make sure he never got charged. And it worked. Because here's what Fentriss understood that no one else did. He hadn't forged anything. He hadn't lied to any clerk. He'd simply filed paperwork in 2 counties that didn't talk to each other, using 2 surveys that both accurately described the same land. Was it fraud? Morally, yes. Legally, The prosecutors couldn't make it stick. Fentriss was never arrested, never indicted, never charged with a crime. He gave one interview in 1988 to a Miami Herald reporter who tracked him down in Nassau. "Do you feel any responsibility for what happened to those families?" the reporter asked. Fentriss paused, sipped his drink, looked out at the ocean. "I sold land I owned to people who wanted to buy it." "What happened after that? The county records, the title companies, the lawyers. That's not on me. That's on a system that doesn't work." "But you knew the system didn't work. You exploited it." Another pause. Longer this time. "In real estate, if you're not exploiting something, you're leaving money on the table." The interview ended shortly after. But the question the reporter didn't ask, the one that should have been obvious from the beginning, was this. If Douglas Fentriss sold the same land twice, and Argent Gulf bought it first, and Meridian Shores built a town on it, then who the hell was Argent Gulf? Because in 1987, when the lawsuit was filed, reporters tried to find them. And they couldn't. No office, no employees, no corporate records beyond the bare minimum required to register a Delaware holding company. Just a P.O. box, a defunct answering service, and a lawyer who refused to return calls. Argent Gulf Properties existed just long enough to buy land in 1979, file a deed, and disappear. And when they reappeared 8 years later to sue Meridian Shores, they did it through a law firm in New York that specialized in one thing: real estate asset recovery. Which raised a question no one in Cape Meridian wanted to hear the answer to. What if the double sale wasn't a mistake? What if Douglas Fentriss wasn't the mastermind? What if he was just the first victim? Chapter 3. The company that didn't exist. The first person to ask the right question about Argent Gulf Properties was a paralegal named Linda Vasquez. She worked for Morrison & Hale, the law firm representing the Cape Meridian homeowners in their class action suit against Meridian Shores Corporation. It was her job to track down corporate records, trace ownership histories, build the paper trail that would prove fraud. In August 1987, her boss handed her a filing cabinet full of documents and said, "Find out everything you can about Argent Gulf. Who they are, where they came from, why they waited 8 years to sue." Linda spent 3 weeks on it, and what she found was nothing. Not nothing useful, literally nothing. Argent Gulf Properties was incorporated in Delaware on February 14, 1979, 2 months before they purchased the Cape Meridian land from Douglas Fentriss. The incorporation papers listed a registered agent, a corporate services company in Wilmington that specialized in forming shell companies for a fee. No officers, no board members, no business address beyond a P.O. box. The company had no tax returns on file, no employees, no bank accounts that Linda could trace. The only financial transaction she could verify was the $340,000 cashier's check they'd used to buy the land in April 1979, and that check had been issued by a bank in the Cayman Islands that no longer existed. Argent Gulf had filed exactly one deed in Collier County in 1979, paid property taxes on the land for 8 years through an automated payment system linked to an offshore account, and then in January 1987, they'd filed a lawsuit through a New York law firm called Kellerman and Associates. That was it. That was the entire footprint of a company that now claimed to own 2,400 acres of Florida coastline, worth an estimated $60 million. Linda wrote up her findings in a 12-page memo and handed it to her boss on September 3, 1987. His response: "This doesn't make any sense." "I know. A company can't just not exist for 8 years and then show up to sue someone." "They can if they're a shell company. They don't need to do anything except own the land and pay taxes." "But why? Why buy land, file a deed, and then do nothing with it for 8 years?" Linda didn't have an answer. Not then, but she kept digging. In October 1987, she tracked down the lawyer who had represented Argent Gulf at the 1979 closing, a man named Martin Schreiber, who'd worked for a small firm in Miami that had since dissolved. Schreiber was retired, living in Coral Gables, and agreed to meet with Linda at a cafe near his house. He remembered the closing, not because it was unusual, but because it wasn't. "It was the easiest $2,000 I ever made," Schreiber told her. "I showed up, signed some papers, handed over a check, and left. The whole thing took maybe 20 minutes. "Did you meet anyone from Argent Gulf?" Linda asked. "No. I was hired by a law firm in New York, Kellerman and Associates. They sent me the paperwork, the check, and instructions. I never spoke to anyone from the actual company." "And that didn't seem strange to you?" Schreiber shrugged. "This is Florida real estate. Half my clients were shell companies. You learn not to ask too many questions." "Do you remember anything else about the transaction? Anything unusual?" Schreiber thought for a moment. "One thing. The check. It was issued by a Cayman bank, which wasn't uncommon, but the amount was exact. Not $340,000 rounded. It was $340,127.50. Like someone had calculated it down to the penny." Linda wrote that down. "What does that suggest to you?" "That whoever was behind Argent Gulf knew exactly what they were doing. They weren't guessing. They weren't negotiating. They had a number, and they paid it." Linda thanked him and left. But that detail, $340,127.50, stuck with her, because it suggested something she hadn't considered before. What if Argent Gulf hadn't bought the land to develop it? What if they'd bought it to own it at the exact moment someone else would try to sell it? She went back to the timeline. Argent Gulf purchased the land in April 1979. Douglas Fentriss refiled his deed in Monroe County in June 1979. Meridian Shores bought the land from Fentriss in August 1979. 2 months. That's how long Argent Gulf had been the sole legal owner before Fentriss pulled his scam. Which raised an uncomfortable question. How did Argent Gulf know to buy that land at that exact moment? Linda pulled the property records going back to 1923. She traced every sale, every transfer, every owner. And she found something that made her stop breathing for a moment. In 1977, 2 years before Argent Gulf was even incorporated, someone had requested copies of the Cape Meridian property records from both Monroe and Collier County. The requests were filed within 3 days of each other. The requester's name was listed as J. Kellerman, research purposes. Kellerman, the same law firm that would later hire Martin Schreiber, the same law firm that represented Argent Gulf in the 1987 lawsuit. Someone at Kellerman and Associates had been studying this property 2 years before Argent Gulf bought it. Linda called the firm. She asked to speak with J. Kellerman. The receptionist put her on hold for 5 minutes, then came back and said, "I'm sorry, there's no one here by that name. Your firm is called Kellerman and Associates. The name is legacy. The original partners retired in the 1980s. Can I speak to whoever handles the Argent Gulf account? That information is confidential." Linda hung up and stared at her notes. Then she did something she probably shouldn't have done. She called a friend who worked in the New York State Corporate Records Office and asked her to pull everything on Kellerman and Associates. What came back was thin but telling. Kellerman and Associates was a boutique law firm specializing in real estate asset recovery and complex property disputes. They had no website, no public client list, no advertisements. They operated almost entirely through referrals. And according to the corporate records, the firm had been founded in 1972 by 2 partners, Jonathan Kellerman and a man named Victor Ruel. Linda ran Victor Ruel's name through every database she had access to: real estate records, court filings, business registrations, and she found him. Victor Ruel had been a Florida land speculator in the 1960s and 70s. He'd made a fortune buying swampland, filing deeds in multiple counties, and selling the same parcels to different buyers. He'd been sued at least 6 times for fraud. He'd settled every case out of court. And in 1978, 1 year before Argent Gulf was incorporated, he'd been disbarred in Florida for unethical conduct related to property transactions. Linda sat back in her chair and felt something cold settle in her chest. Victor Ruel knew how to exploit Florida's broken county system because he'd been doing it for years. And in 1977, he'd sent someone to study the Cape Meridian property records in 2 different counties. Then, in 1979, a shell company connected to his law firm bought that exact property. 2 months later, Douglas Fentriss, a desperate, indebted land consultant, suddenly decided to commit the exact type of fraud Victor Ruel had built a career on. And 8 years after that, when Cape Meridian was a thriving town worth $60 million, Argent Gulf reappeared to claim it. Linda wrote this up in a second memo. She titled it, Argent Gulf Properties, Possible Entrapment Scenario. Her theory was simple. Victor Ruel had identified a piece of land vulnerable to double filing. He'd created Argent Gulf to buy it legitimately. Then he'd waited for someone, anyone, to try to exploit the same loophole he'd spotted. When Douglas Fentriss did exactly that, Ruel let him. Let Meridian Shores build the town. Let the homeowners move in. Let the property value skyrocket. And then he sued. Not for the $340,000 Argent Gulf had paid in 1979, but for the land itself, now worth $60 million. It wasn't fraud. It was a trap. And 1,200 families had walked straight into it. Linda's boss read the memo twice. Then he called a meeting with the senior partners. "Can we prove any of this?" one of them asked. "No," Linda admitted. "Ruel's name doesn't appear on any Argent Gulf documents. The connection to Kellerman and Associates is circumstantial, and even if we could prove he set this up, I'm not sure it matters. Argent Gulf bought the land legally. They filed first. Fentriss committed fraud. The law is on their side. So what do we do?" Linda looked around the room. "We ask Victor Ruel directly." In November 1987, Morrison and Hale filed a motion to depose Victor Ruel as part of the Cape Meridian case. Kellerman and Associates fought it for 3 weeks, but in December, a judge ruled in the homeowner's favor. The deposition was scheduled for January 15, 1988. Victor Ruel never showed up. On January 12, 1988, 3 days before the deposition, Kellerman and Associates filed a motion to withdraw from the case, citing conflict of interest with client directives. The motion was granted. The next day, Argent Gulf Properties filed for voluntary dissolution in Delaware. The company was liquidated. The Cape Meridian property claim was transferred to a new entity, a trust based in the British Virgin Islands with no listed beneficiaries. And Victor Ruel disappeared. Not literally. He was still alive, still practicing law in New York under a different firm name. But he'd severed every visible connection to Argent Gulf, to Kellerman and Associates, to Cape Meridian. Linda Vasquez tried to track him down for an interview. He declined. She tried subpoenaing him. His lawyers blocked it. She tried finding anyone, former employees, former partners, anyone, who would talk about what Argent Gulf really was. No one would. In March 1988, the case was settled out of court. The trust agreed to sell the Cape Meridian land back to the homeowners for $12 million, 20 cents on the dollar, to be paid over 10 years. Most families couldn't afford it. They lost their homes anyway. Robert Kensington was one of them. Linda never forgot the day she had to tell him. He sat across from her in the conference room, holding the settlement papers, and said very quietly, "So we were bait." "I think so, yes. They knew someone would try to scam this land. They just waited for it to happen. That's my theory. I can't prove it." Robert nodded slowly. Then he asked the question Linda had been asking herself for months. How many other towns are out there? How many other traps did they set? Linda didn't answer, because she didn't know. And that was the most terrifying part. Chapter 4. The map no one wants to see. In April 1988, 3 months after the Cape Meridian settlement, Linda Vasquez did something she wasn't supposed to do. She stopped working on cases her firm assigned her and started working on the case that wouldn't let her sleep. She'd been having the same nightmare for weeks. She'd dreamed she was standing in the middle of Cape Meridian, watching families pack their belongings into moving trucks, and everywhere she looked there were more towns just like it. Identical streets, identical houses, identical letters arriving in identical mailboxes telling people their homes had never been theirs. And in the dream, she'd pull out a map and start marking them. 1 town, then 5, then 20, until the entire coastline of Florida was covered in red circles, each one a trap that had been set years ago and was still waiting to spring. She'd wake up sweating, and then one morning in April, instead of going to work, she went to the Florida Department of State Records office in Tallahassee. She told her boss she was sick. She told her husband she needed a few days to think. She checked into a cheap motel near the Capitol building and spent 72 hours doing something that would either prove she was right or prove she was losing her mind. She started mapping Victor Ruel's career. She pulled every property transaction, every court filing, every deed registration she could find connected to him or any company he'd been associated with. She went back to 1965, when Ruel had first started practicing real estate law in Florida, and she found a pattern. Between 1965 and 1978, the year he was disbarred, Victor Ruel had been involved in at least 43 land transactions in Florida. Most were routine, but 11 of them had something in common. They were all coastal properties between 1,000 and 3,000 acres. They were all located in areas where county lines intersected or where survey records were incomplete. And they had all been sold at least twice, once legally through Ruel's clients, and once through what appeared to be clerical errors, refiled deeds, or what one judge had called exploitative use of inconsistent county recording systems. Ruel had been sued 6 times. He'd settled every case quietly. He'd never been convicted. And in every settlement, the language was the same. No admission of wrongdoing, sealed records, non-disclosure agreements. Linda wrote down the locations of all 11 properties. Then she did something that made her hands shake. She cross-referenced them with Delaware Shell Company registrations between 1975 and 1985. And she found them. Not all 11, but 7 of them. 7 coastal properties in Florida that had been quietly purchased by Delaware Shell Companies in the late 1970s and early 1980s. Companies with no employees, no offices, and no activity except paying property taxes and waiting. Waiting for someone to commit the same fraud Victor Ruel had taught them was possible. Linda spread a map of Florida across her motel room bed and marked each location with a red pen. Cape Meridian was one, but there were 6 others, 3 in the Panhandle, 2 near Tampa, 1 outside Jacksonville. Some of the properties were still empty, undeveloped land owned by shell companies that had never built anything. But 2 of them had been developed, small communities, not as big as Cape Meridian, a few hundred homes each, places with names like Sunset Keys and Gulf Breeze Estates, places where families lived right now, in houses they believed they owned. Linda felt sick. She picked up the phone and called the county clerk's office in Panama City, where one of the Panhandle properties was located. She asked if there had been any recent property disputes involving a development called Sunset Keys. The clerk put her on hold. When she came back, her voice was quieter. "There's a sealed file. I can't give you details, but there was a lawsuit filed in 1985. It was settled out of court. The records are closed." "Who filed the lawsuit?" "A company called Coastal Holdings, LLC, Delaware registration." Linda hung up and stared at the map. Coastal Holdings, LLC. She ran the name through the corporate database. It had the same structure as Argent Gulf, same registered agent, same Cayman bank account, same law firm listed on the dissolution papers, Kellerman and Associates. She called the county office in Hillsborough County, where one of the Tampa properties was located. "I'm researching a property called Gulf Breeze Estates. Have there been any ownership disputes in the last 10 years? The clerk checked. There was something in 1983, a quiet title action, settled privately. "Who was the plaintiff?" A trust. No name listed. The file is sealed. Linda made 6 more calls that day. 4 of the properties had no disputes on record, yet. But the other 2 had both been involved in sealed settlements within the last decade. She drove back to Miami that night and didn't sleep. The next morning, she walked into her boss's office and put the map on his desk. "What is this?" he asked. "Proof." She explained everything: the pattern, the shell companies, the sealed settlements, the coastal properties sitting empty or half-developed, waiting for someone to trigger the trap. Her boss looked at the map for a long time. Then he said, "This is speculation. You can't prove any of this." "I can prove there are 7 properties in Florida with the exact same ownership structure as Cape Meridian. I can prove they were all purchased by shell companies connected to the same law firm. I can prove at least 3 of them have already been involved in sealed property disputes." Sealed, which means we can't access the records, because someone doesn't want us to. Her boss leaned back in his chair. "Linda, even if you're right, even if Victor Ruel or someone like him has been setting land traps all over Florida for 20 years, what are you going to do about it? You can't sue a pattern. You can't subpoena a theory. We can warn people. Warn them how? Go door to door in developments you think might be fraudulent and tell families their homes might not be legal. You'd start a panic. You'd get sued for defamation. And for what? Most of these traps might never spring. Some of them might be legitimate. And if they're not?" Her boss didn't answer. He just looked at the map and shook his head. Linda walked out of his office and didn't go back. She quit Morrison and Hale the next day. She took the map, her notes, and everything she'd compiled and tried to find someone who would listen. She called the Florida Attorney General's office. They said they'd look into it and never called back. She contacted the FBI. They said property fraud was a state matter. She reached out to investigative journalists at the Miami Herald, the Tampa Bay Times, the Sun Sentinel. 2 of them interviewed her. One wrote a story, but it was buried on page 14 and framed as paralegals' conspiracy theory about shell companies. No one cared. Or more accurately, no one wanted to care. Because if Linda was right, if there really were land traps scattered across Florida, waiting to destroy families who believed they owned their homes, then the entire system had failed. The county clerks, the title companies, the lawyers, the banks, everyone who was supposed to protect buyers had either been complicit or incompetent, and admitting that would cost billions. In June 1988, Linda gave one final interview. A freelance reporter from a small weekly paper in Fort Myers tracked her down and asked if she still believed her theory. "I don't believe it," Linda said. "I know it. But you can't prove it. Not in a way that matters to people who don't want to see it." "So what now?" Linda looked at the map she'd been carrying in her bag for 2 months. 7 red circles, 7 traps. Some sprung, some still waiting. Now? I hope I'm wrong. I hope those other 6 properties are clean. I hope the families living in those developments never get a letter like the one Robert Kensington got. And if they do, Linda folded the map and put it away. Then we'll know this wasn't about Cape Meridian. It was never about one town. It was a system, a business model. Find vulnerable land, buy it quietly, wait for someone else to commit fraud, let them build, let the value grow, then take it all. The article ran in July 1988. Almost no one read it, but Linda kept the map. She kept her notes, and every few months, she'd check the property records for those 6 red circles, waiting to see if another lawsuit had been filed, another settlement sealed, another town erased. As of 1995, the last time she checked before moving out of Florida, 4 of the 6 properties were still owned by shell companies. No development, no lawsuits, just land sitting quietly on the coast, waiting. One property had been sold to a legitimate developer in 1991. The shell company dissolved. No trap was ever sprung. But the 6th property, a 1,800-acre parcel near Destin, had disappeared from the public record entirely. In 1993, the deed was transferred to a trust in the Cook Islands. The property taxes were still being paid, but there was no owner listed, no development plans, no explanation, just silence. Linda tried to find out what happened. She called the county office. They said the file had been archived for space. She requested a copy. They said it would take 6 to 8 weeks. She never received it. She thought about driving to Destin to see the land for herself. But she didn't, because part of her didn't want to know. Didn't want to see the for sale signs, or the half-built houses, or the families who might be living on borrowed time. In 1996, Linda Vasquez left Florida. She moved to Oregon, changed careers, and tried to forget about the map. But she never threw it away. It's still in a folder in her garage. 7 red circles on the Florida coast. 1 city destroyed. 6 question marks. And the question she never stopped asking. If someone was smart enough to set 7 traps, how many more did they set that she never found? How many families are living in houses they don't own, in towns that don't exist, waiting for a letter that will destroy their lives? The answer, she realized, wasn't on any map, because the real trap was never the land. It was the belief that the system would protect you, that deeds meant something, that if you signed the right papers and paid your mortgage and did everything you were supposed to do, you were safe. Cape Meridian proved that wasn't true, and somewhere in Florida, or California, or Texas, or any state where land records are messy and counties don't talk to each other, there might be another Cape Meridian waiting to happen. Not because someone committed fraud, but because someone made fraud inevitable, profitable, and legal, and then waited.